Right, good afternoon everyone. It's 2 o'clock, so we'll make a start. Item 1 on the agenda is apologies for absence. Are there any apologies?
I've got apologies from Councillor Cooper, Councillor Peter Elliott and Councillor Heather Liggett. Councillor Peter Elliott has sent Councillor Baker as substitute.
Thank you for that, Amy. Right, item 2 is declaration of interest. Members are requested to declare the existence and nature of any disclosable pecuniary interests and or other interests not already on their register of interests in any item on the agenda and withdraw from the meeting at the appropriate time. Do any members have any interest to declare? No. Thank you, members. Item 3. Any member who cannot determine an application solely on the information presented to committee at the meeting today is asked to declare that they are predetermined on that item on the agenda and withdraw from the meeting at the appropriate time. Do any members have any predetermination to declare? No, thank you. Item 4. Minutes of the last meeting. We now have the minutes of the last meeting held on the 20th of May 2025. Are we happy that they are a correct record? If you can just have a show of hands, or propose and a second of first. Oh, yeah, okay. Thank you. Right, we now move on to the first application on our agenda today, which is NED/24/00847/FL, Pilsley and Morton. The first application is in respect of the corner pin Station Road at Morton. I'm now going to hand you over to Alice to give us a quick brief explanation of the application before us. Thank you.
Thank you, Chair. This application is for the change of use with no external alterations from public house to mixed use public house and convenience store at the corner pin, Station Road, Morton. The applicant has submitted amended plans as originally they applied to change the use of the whole pub to a shop. This was considered inappropriate as it would have resulted in the total loss of the public house, which is considered a piece of social infrastructure. Since the late REPS document was published, we have had 2 further comments from the speakers today. They bring up the following issues. The existing layout is not correct. I will deal with this later in the presentation. No additional parking has been shown. I will also deal with this in the presentation. The condition restricting the pub opening hours will not work. Officers are of the view that the restrictions on the pub opening hours could be removed without prejudicing the rest of the proposal. We have also received an email from Mr. Gregory that we believe all members have seen. We believe this raises matters wholly not material to the application and which, as a result, have not been reported in detail. Finally, I checked this morning and the council has not received an application to register the corner pin as an asset of community value. The site is located on the junction of Station Road and Pilsley Road at Morton. This plan shows the site a bit closer in. And this is the site location plan. And this is the proposed block plan. This is the principal elevation of the corner pin. It is proposed that the 2 right-hand rooms of the existing pub layout will be converted to a convenience store, whilst the left-hand room remains in use as a public house. The application site is located within the settlement development limits for Morton, where policy SS7 supports development provided that it is appropriate in scale, design and location to the character and function of the settlement, does not result in the loss of a valued facility or service, is compatible with and does not prejudice any intended use of adjacent sites and land uses, and accords with other policies of the plan. Both public houses and local shops come under the definition of social infrastructure. Policy ID5 does not permit the loss of social infrastructure unless it can be shown that the facility is no longer needed or that the service could be adequately provided in an alternative way or elsewhere in an alternative location that is equally accessible. Or it can be demonstrated through a viability assessment that the current use is not economically viable. However, the policy is worded clearly that it is the loss of the facility which is not supported. In this case, the floor plan shows that part of the pub will remain, albeit reduced in size, and in addition, the remainder of the public house will be replaced by another form of social infrastructure in the form of a shop. As a consequence, officers are of the view that the proposals will not result in a loss of social infrastructure, and therefore the proposal meets the requirements of Policy ID5. Consequentially, it was not considered necessary to closely question the financial arrangements to justify a loss, because no loss was occurring. If members are minded to approve the application, it is recommended that this layout is conditioned in order to retain the area of the public house. This layout will have to be delivered, which means that if the existing layout drawings are incorrect, the applicant will have to reconfigure the interior to deliver this scheme. The site already has permission for a hot food takeaway. An application has been submitted to regularise the positioning of an in-post parcel storage locker. You can see both in this picture. As a consequence, there is a potential that if the shop application is approved, the site would have a number of uses: public house, shop, hot food takeaway and parcel storage locker. Added to this is the presumed extant use of the residence above the pub. Members should note the fence on the left-hand side of the photo. As you can see from this aerial photo, the car park is divided by the fence between the outbuilding and the public house. This will be removed to deliver the parking, so that's why they will have space for the parking that I'll show later. This is the parking layout that was approved with the hot food takeaway. However, the parking layout was not specifically conditioned, so the council has no control over that. The applicant has submitted a parking assessment based on the shop closing at 6:30 in the evening. This suggests that 8 parking spaces will be sufficient. This drawing shows that because the fence across the back of the car park will be removed, there will be 8 parking spaces made available on the site. The lean-to shelter on the back of the pub will also be removed. If members think it necessary, this can be secured by condition. The Highway Authority did their own assessment and concluded that likely worst-case parking requirements would be between 8 and 17 spaces. They concluded that there is sufficient highway parking in addition to the laid-out car park to accommodate this. The Highway Authority have, however, requested a traffic regulation order to prevent parking too close to the junction between Station Road and Pilsey Road. This should be secured by legal agreement if permission is granted. Local and national planning policy aims to support development within the settlements where it does not result in the loss of social infrastructure and meets with other requirements of the plan. In this case, it is proposed to change the use of the corner pin to a mixed-use pub and shop, which will run alongside the existing residential use and approved hot food takeaway. Both uses are considered forms of social infrastructure. As a pub will be retained, it will not result in the loss of a piece of social infrastructure, and as such, officers are of the view that the application will meet the requirements of Policy SS7 and ID5 of the North East Derbyshire Local Plan. As a consequence, it is considered that the resulting mixed use of the site as a pub and shop, takeaway and takeaway as described is acceptable. The parcel storage facility application will be judged on its own merits, but is not considered prejudicial to the determination of this application. The Highway Officer has confirmed that subject to the traffic regulation order and conditioning of shop opening hours, the proposal will not have harmful impact on highway safety. As no building is proposed, there will be no impact on lights, windows, and it's concluded that the impacts of movement, such as deliveries and vehicle comings and goings, can be mitigated by means of condition. As such, we do not think it will harm the amenity or privacy of neighbours. Officers are also of the view that there is no other technical reasons to refuse the application, and overall, officers consider the proposal accords with the development plan and there are no material matters that outweigh that conclusion. As such, it's recommended that permission is granted. Thank you, Chair.
Thank you for that presentation, Alice. Right, we have 2 registered speakers on this application. The first of which is Mr. Stephen Gregory, who is speaking as an objector. If you'd like to come up to the speakers table, please. You have 3 minutes when you're ready. Thank you.
I bring with me 3 folders to the meeting to bring to the attention of the officers. The first one are the applications, amended plans, revised plans, and all the other paraphernalia that have been submitted by the applicant. The second contains letters and comments of objection, including a 199 customer-signed petition objecting to the proposals put forward and the reduction in size of the public house to one which will only accommodate 12 people. The third contains letters in favour. Not one received. The truth is, the corner pin is the community care centre the council would love to provide if funding in this county was not so biased in favour of central rather than local government. The pin is the place where the 199 people signed the petition and others go, especially now the bus service has been withdrawn, to arrange someone to collect a prescription or a lift to the doctors or a hospital appointment, to seek the help of the regular tradespeople with an emergency repair or some professional advice. Above all, it's a meeting place where many elderly and lowly community members gather to stabilise their mental health, well-being and sanity. The regulars are not only their friends, but they are their only family. The process of applying for the PIN to register an asset of community value has had to be placed on hold, but it will be resumed. The widow who was organising the application was late arriving at the PIN one evening. This being so very unusual, one of the bar staff tried ringing her, and upon receiving no answer, she and a couple of regulars went home. The old lady was found at the bottom of the stairs with multiple fractures and a cracked skull. Her broken mug of cocoa was by her side. She had been there for 18 hours. She was rushed to Queen's Medical Centre at Nottingham Forest, where for the next 9 days, staff and customers from the PIN went to visit her. Unfortunately, she did not make it. Her funeral is tomorrow. Regulars have organised floral tribute and the wake she arrived at the PIN. 80 plus people will attend. A memorial plaque has been commissioned. It will be placed on the PIN wall alongside the others which honour past characters of the PIN community. In their memory, in support of all those who have commented, and on behalf of the 199 customers who have signed the petition, I respectfully ask the committee to refuse this application and/or defer decision until an internal and external site visit has taken place, allowing members to determine if the current proposals and submitted plans could possibly allow this proud community hub to continue its current functions. The recommendations made by your officers are based purely on the ever-changing fictional information supplied by the applicant's employed agent, who, I'm informed by Officer Alice Lockett, has so far been unhelpful in regarding an internal inspection. One could only ask why. Thank you.
Thank you, Mr. Gregory. Right, members, do any members have any questions? Mr. Gregory? Nope. If you'd like to retake your seat then, please. Oh, sorry. Can you just 1 second? Councillor Baker.
Thank you, Chair. What is the main, do you say is the main difference between the plans submitted and of the existing layout and the layout that as is?
The plans that you have, the toilets are in the wrong position, the stairs are in the wrong position, the entrance to the cellar is in the wrong position, walls have been omitted that have since been built since the plans were done. The plans were basically drawn up over 20 years ago and have been copied.
Thank you very much.
Okay. Thank you. If you'd like to retake your seat, thanks. Our next speaker on this application is David McCabe, also an objector. If you'd like to take your seat, please. You've got 3 minutes when you're ready. Thanks.
Okay, good afternoon, everybody. I find it quite astonishing that the committee has decided that there will not be a loss of social infrastructure in this application. Admittedly, immediately, yes, part of the pub will remain, but the long-term safety of that pub is likely to diminish very quickly, simply because due to the reduction in size of the pub, which doesn't make it really appropriate for the number of people that use the venue, and also the reduction of the hours, although that has been commented that that could be reviewed as well. So reducing by the pub size by around about 60 to 70% at least, and also the reducing in hours of 30% will simply warrant the pub in practical to actually continue in its current status and the volume of people that actually use the facility. For example, this evening we have a home Skittles game, and there'll be around about 30 to 40 people attending that match. That team and that part of the community aspect will not be able to continue should this plan be allowed to continue in its current form of a dual use purpose there. Secondly to that, I would also like to point out that throughout the application, misleading information seems to have been presented all over the place just to create this narrative of that the pub simply isn't being used by that many people, and hence that a reduced size is more than adequate for the situation. An astonishing suggestion that only 4 people use the pub and they only take £100. I know you're not excluding financials in that, is quite ridiculous. On top of that, also the plans, which was also been challenged to be very, missing stairwells, walls, doors in the wrong place, non-existent doors, etc. Just seems to be all the way through this application there's been misleading, if not false, information provided to the committee to make a decision. And I believe that a decision's been made with the wrong information at hand to themselves. So it's my opinion that this should be immediately dismissed because of the false information that has been provided to the committee, and also the fact that the dual purpose is simply not going to be suitable for the long-term prosperity of a social infrastructure for the community. I believe this is a backdoor approach to basically get an application for the shop purpose, and then in a short space of time, whether that's 6 months, 12 months, 18 months, whatever it'll be, there'll be a future application to remove the pub side aspect of the building, simply because genuinely then it won't be used because nobody can use the pub. A very limited select number of people will be able to fit in the pub. So you couldn't have celebrations, birthdays, wakes, community events, celebrating times like at Christmas. And so the numbers will just dwindle down because people won't attend because there won't be space for them to use the facility. Hopefully the committee will agree with me there, and hopefully at least review and if not dismiss this application based on all that. Thank you very much.
Thank you very much for that. Do members have any questions for the speaker? No, if you'd like to retake your seat then, please. Right then, members, it's now time to ask any questions of officers. Have we got a starter? Thank you. Councillor Foster.
Thank you, Chair. Yeah, I'll make a start. My first concern I'd raise to officers is regarding policy ID5. I've read about this and studied this before I came to the meeting, like many of us have, but Mr McCabe touched on the exact same point which I was going to bring up. If we look at what ID5 says on page 163 of the local plan, development proposals which would result in the loss of social infrastructure facilities will not be permitted. So if we accept this, first of all, is social infrastructure, I'm told it's the only pub in Stonebrew, and for me a shop wouldn't be social infrastructure because there are another 10 shops within 2 miles. I'm making that assumption there. So the pub is social infrastructure. So because it's leaving part of a pub there, it's not considered a loss of social infrastructure. But if we look at the actual wording and the spirit, so both the wording and the spirit, it says development proposals which would result in the loss. If we were to permit this, and by giving this permission, it resulted, we're looking at the actual words, it resulted in the loss, then I think it would be going against the spirit and the word in ID5, because pubs have a hard enough time surviving as it is. Looking at that plan, if the plans are accurate, which is one of my other questions which has been raised, if that is accurate, and we look at the size of that pub that would end up being there, which looks like the size of those 2 toilets, how viable can that be? If you look at how our pub's managed, how many pumps can they afford to put on? If they're only serving a maximum of 12 and it looks like less than 12, how can they hold the barrels without them going off? So how viable would it be? So by us giving it permission, it may well be we're putting it up for loss of a business, and then later on ID5 would work because we've given it permission, this could happen, ID5 would be in the position of, under B, it can be demonstrated through a viability assessment. What that would be, yeah, you could then demonstrate it at a later date through a viability assessment. We've only got one room, maximum of 12 people, size of 2 toilets. It's not viable anymore. We want now. Now, I know we can't take that into account what might happen in the future. I'm experienced enough here to know that. However, if at this point we give permission, does it result in the loss of a social infrastructure? Are we making that pub unviable? So I know we're not in debate at this point, Chair, but that's my question to officers. Have we considered giving permission? Would it result in the loss of social infrastructure? So this, in word and in spirit, much like Mr McCabe's come along and explained to us. Thank you, Chair.
I think we have thought about that and we've concluded.
Your
that
microphone's not on yet.
Oh, sorry.
It's on there. That's it.
Sorry, we have thought about that and but concluded that the we can't take into account what could happen in the future. We also can't force people to run their business, so it doesn't result in the loss of a pub. It results in the loss of floor space of a pub, but not an actual pub. And the policy is not is perhaps not clear enough to prevent this situation from happening. We do agree it is social infrastructure. If you look at, I think it's a few, in the explanatory text of that policy, shops are also classed as social infrastructure. So, and there's no clarity, it's not totally clear as to whether that policy allows the replacement of one form of social infrastructure with another. It doesn't, it's silent on that. So that's how we've come to that conclusion after quite a lot of thinking about it. But clearly, members are perfectly, okay to consider that differently. But I don't think we can consider what might happen. As you said, we can't do that. We can only consider what we've got in front of us.
Thank you, Councillor Foster.
If I can just come back on that, the point about the shops is, yes, they might be considered in general social infrastructure, but not when it comes to there's another 10 shops within the 2 miles. So it's not like, that's the point I made on that.
The policy doesn't, and the supporting documents don't distinguish between shops where there are more than one shop and shops where there are not more than one shop. So, of course, yeah.
Right, thank you, members. Councillor Baker.
Thank you, Chair. Regarding the parking layout shown in 7.8 shows a good turning area and vehicle paths turning into the area close to the pub itself, which seems to be borne out by the photograph taken on a winter's day and the tyre tracks in the snow. On the proposed parking layout, parking is shown in that area. Our officers content that there is sufficient vehicle manoeuvring room on the proposed parking layout to accommodate the 8 parking spaces shown.
So the parking layout is different from what's actually on the ground at the minute because that fence will be removed. So what you're seeing on the ground in that photograph is not what this parking layout will be. Highways have seen this parking layout and haven't raised an objection. So we are of the view that it can be delivered.
My question is really, can a vehicle actually turn around in that small space that is shown on that layout when you consider how much space was required on the previous layout and how much is normally given for a vehicle to turn around? Bear in mind they might be 5 metres long, trying to turn around in such a small zone. That's what I'm asking. There's no swept path or no arrow indicating how the vehicles would turn around in there and enter the site and leave in forward gear.
That's correct. There isn't a swept path. The layout shown in Figure 4 from the hot food takeaway application the rear shelter is still present. It's not present on the proposed layout for the shop application. I haven't done a swept path, I can't do that, but the highways have seen this scheme and have said that they have no objection, subject to the traffic regulation order. So we would normally defer to them when it comes to these sorts of issues.
Okay. Councillor Jones.
Can I just ask, I realise that you have to make your decision based on all of the information placed in front of you. I acknowledge that, and that's a fact of life. However, you've made comments in your report about not visiting site and not getting access into the pub. We've heard the objectors making the same sort of comment. Did you try and get access, or do you not, didn't consider it an important point?
I believe I did ask once if I could get access inside, but they didn't come back to me, and I concluded that, as I've said, so long as we condition that layout that retains part of the building as a pub, then it's their problem. If they've submitted the wrong layout to start with, and they're going to have to completely configure the pub to deliver the thing that we are, if you grant permission, we will condition, then that's their problem. So I don't think it would have made any difference to the ultimate decision, and I didn't pursue it any further.
Okay.
Can you just turn your mic up, William, please?
Sorry.
Councillor Foster.
Thank you, Chair. I was going to raise much to the same issue as mentioned by Mr. Gregory about the accuracy of the plans, but I think you've already covered that. One concern I'd like to raise is on page 12 of the report, and it's the third bullet point down and the last of the bullet points before section 6. So it says there, people already park dangerously, the proposal would make it worse. This is a comment made by residents or objectors, which has been added to the report. And the last bullet point is parking on the front of the existing public house would result in people reversing onto the highway. So this is residents and objectors, in their own words, raising concerns about what they think might be dangerous. What concerns me is that the officers have replied, illegal parking should be dealt with by the police. And illegal parking and manoeuvring should be dealt with by the police. That's the answer in both cases. I think that dismisses residents' concerns here and objectors' concerns, because yes, illegal parking is dealt with by the police, but these people aren't talking about illegal parking. They're talking about what is dangerous, what they consider dangerous. So I don't think those are fair replies to objectors, and I don't think it's fair guidance to people sat on this committee, because traffic and highway safety is a concern, is a material consideration. I'll be corrected on that by officers, but as far as I know, highway concern, and now I know we receive reports from highways, DCC on that, but for people to say, for objectors to say people already park dangerously and parking on the front of this public house would result in people reversing onto the highway, these are relevant, and to counter them with illegal parking and manoeuvring should be dealt with by the police in both circumstances, I don't think it's appropriate. And if we're not careful, that'll lead this committee away from, no, we're not concerned about that. That's not relevant. It is relevant, and highway safety is a concern, and it's something we should consider. If we think it's, as a committee, that it is a consideration being raised by objectors and concerned residents, we should then be looking at policy and where in the NPPF and where in our local plan it can be tackled and we can consider it. It shouldn't be dismissed as in it's just the police that look at this. I hope that's taken by officers in the way that I meant it, but we shouldn't be answering objectors like that and dismissing concerns about highway safety, which weren't brought up as illegal. Thank you, Chair.
Was there a question there, Councillor?
Need an answer to that.
You can comment on it if you like. I can frame it as a question if you want. Thanks.
It is questions to officers.
Do you want an answer?
Okay, well, I'll have an answer on that. Why is it done like that? Thanks.
Because we can't consider, we can only consider the impact of the proposed development. And if people choose to park illegally, we can't, the applicant is in control of that. That's the choice of the person who's parked illegally. It's not a material planning consideration. That's why I've said that. And if so, however, the Highway Authority have picked up on that and have said that they need the traffic regulation order to put some double yellow lines around that area. So there is obviously an issue with people parking illegally, but that can't be in the control of the applicant.
Thank you. Councillor Baker wants.
Can I follow on from the same point, because it was my question wasn't answered.
Okay, quickly.
Yeah, I appreciate that, Chair. Thank you, Councillor Baker. Yeah, it was the difference between people parking dangerously and people parking illegally. I understand illegal parking is dealt with by the police. These comments, if you read them, aren't people talking. The objectors aren't talking about illegal parking. They're talking about dangerous vehicle activity. You can see it.
But
People
again,
people already park dangerously and parking on the front of this house, resulting in people reversing onto the highway. They're not talking about illegal manoeuvres. What they're talking about is people being dangerous. It's a question about highway safety. So what I'm concerned about is it being dismissed because it's illegal, when actually it's a concern about highway safety. Does anybody else get this, or is it? Thank you, Chair.
The dangerous parking is illegal parking. There's no proposal to park on the front, on the pavement or the immediate area outside the front of the pub, which I think is I don't really quite know what they mean by people reversing onto the highway, but there's no parking spaces are proposed at the front of the pub. If you look in the plan, they're all proposed in the car park. So if people are parking on the pavement, on double yellow lines, on too close to the junction, or any other parking that is illegal as far as the highway code is concerned, then that's a matter for the highway, the police, effectively. So this development, the owners of this development can provide parking, but they can't control how individuals choose or choose not to use that parking. And in that case, these issues are not material to this planning application. They are problems that are caused by people parking illegally in one way or another. And that's why, you know, but notwithstanding that, the Highway Authority have accepted that there is an issue with parking here and have asked for the traffic regulation order. So we've not dismissed those concerns. We've dealt with them. So anyway.
Thank you, Alice. Councillor Baker.
Thank you, Chair. My question is regarding the use of the upstairs. Can you enlighten the committee what's proposed with that, please?
The upstairs has not been mentioned by the applicant. We have assumed that there's an extant use as a dwelling, because that's normal above pubs. Whether or not that's actually being used at the moment, we don't know, but that doesn't matter, because so long as it's extant, there's no application to change that use to anything else. We're making an assumption that somebody could live there at some point. And we've calculated that into the parking requirements.
That's in the parking assessment. Thank you very much.
Thank you. Any more questions for officers? No, right. If there's no further questions, we'll move on to the debate. Just before we do that, has that officer's got anything they'd like to add?
Just if I can add one thing, Chair, to the question that Councillor Foster's asked and Alice has answered, just to bring another element to that, and we've talked about this many times at committee, as Councillor Foster and other members will know, is that those allegations are made by third parties, as Councillor Foster's mentioned. People park dangerously, and parking in front of the existing public house will result in people reversing onto the highway. And Alice has quite rightly said that matters of illegality are dealt with another party, but Councillor Foster is correct that matters of highway safety are a matter for members to consider on the light of the requirements of the MPPF, paragraph 116, I think it is, in terms of the MPPF. The one thing I would add to that, Chair, is that the comments made by the third parties are comments that are made, and in considering those in the matter of highway safety, members need to have information and evidence to place weight on those factors in coming to your conclusions. So the comments may have been made by third parties, but what evidence do you have that parking is a problem, that highway safety is a problem? So I just urge caution, as I always do on that matter, that in weighing that particular issue, you need to have evidence and facts on which to base your assessment, and the assessment of whether the development as a whole is adversely impacting highway safety and having that severe impact. Thank you, Chair.
Thank you, Adrian. Right, the floor's open for debate. Anybody want to add? Right, I'll make a start.
It's debate after you, Chair.
Right, all I was going to say is I think it's, and I found it very sad over the years watching the number of pubs go bust. But unfortunately, the economics of these things have a big impact on villages throughout the district. But as it stands, while we have not received information on whether this is the pub is financially viable, we've got an application before us that does seem to meet a lot of the criteria within our policy, particularly RD5. So with that in mind, I think I will be supporting officers' recommendations. Councillor Baker.
Thank you, Chair. When I first saw this, I was concerned about the intensification of the whole development on quite a small site. Bear in mind, a hot food takeaway has already got permission, and we don't know what the planned use of the upstairs is. Could be flats, but apparently we understand the parking might be allowed for that. My biggest reservation is what I think Mr. Gregory said, and is in the list of objected comments. Is a public house for 10 people maximum actually viable? And are we actually giving permission for the ending of that pub? And that then, once the principle of the shop conversion has been allowed, it will be relatively easy to vary the condition, remove the pub and extend the shop. That would be my reservation. And I'm happy about it.
But that's not the application that's before us.
Yeah, the
So we've
application
got to-
before us is
We can
what
only
it is.
judge the application that's before us. Councillor Foster.
Thank you, Chair. I get the difference. I fully understand the difference, as in, much like you said, Chair, that we're not considering getting rid of the pub and having a full shop at this point. And I'm not considering that either. I'm making the same consideration that I'm hearing from Councillor Baker, what I spoke about earlier when I was asking questions to the officer. And that's that ID5, and I think it's a grey area, and I think officers might agree that it's a grey area, might do, but we can't hear from them anymore because we've passed officers' questions. That development proposals which would result in the loss of social infrastructure, this will result in it. And it's not a guess. If it's not viable now, or they're not making tons of money at it now, they certainly won't be making lots of money with one small room the size of 2 toilets. So this proposal will result in it, no more than that. So I won't be supporting this. Thank you, Chair.
Thank you, Councillor Foster. Councillor Peterson.
Yeah,
Can you put your mic?
sorry. You've said about third-party comments that we have to not. If you've not been inside the pub, aren't you taking third-party ideas because you've got no proof of what that layout is? So isn't that third party? Am I being disingenuous?
I'll have to come back to that, Chair, but I'm mindful that this is your debate section, so
Yeah.
I'm happy to come back if you'd like me to. On that
I
point.
think that's already been answered, to be honest, in the fact that we we work into a plan that we've been given, and that is the developer who's the applicant has got to follow that plan that's before us. Yeah, Councillor Jones.
I think I need to share my concerns as well. I'm very concerned about the fact that that pub is so small and will be quite unviable. And I don't think I can either support this. I can't support it. Thank you.
Thank you, Councillor Jones. Councillor Foster.
Thank you, Chair. Can I just say at this point, thank you for that. This is actually a debate between councillors, whereas normally it's a debate between councillors and officers. So I'd like to thank the Chair for that.
Right, anybody else want to enter the debate? Any thoughts on this application? No, right, I will open. Councillor Lacey.
Yeah, I'd like to put in a motion that we go with officers' recommendations.
We've got a seconder for that. Councillor Rouse, thank you. Right, well, we'll put that to the vote. Right, members, thank you very much. That's 5 in favour, 3 against and 1 abstention. So officer recommendation has been accepted. Thank you, members. Where have they gone? It'd be nice if you did. Took my jacket off. Right, we'll now move on to item 6 on the agenda, which is our second application of the day, which is NED//223/00223/FLH Unston. The first application in respect of Roslings Hundle. I'm now going to hand over to Ken Huckle to give us a brief outline of the application.
Thanks, Chair. The proposal is for a two-storey front extension with potential future permitted development rights removed at Hundall. The application site is a two-storey dwelling located in Hundall, which has a rural field comprising scattered farmsteads and dwellings. It lies outside of any defined settlement development limit and within the green belt. The original dwelling was built pre-1948 but was substantially extended in 1985, representing a 70% increase in size compared to the original dwelling. The next slide shows this more closely. Slides 3 and 4 show the location plan and site plan, showing the relationship of the dwelling to the site and the road. Yeah, next slide. Thank you. Next slide then, please. Okay. The proposal seeks consent for a further two-storey extension to the front of the property. It is the suggestion of the applicant made in the application details and reflected in the application title that if the application is permitted, household of permitted development will be removed, which will be discussed later. Both local and national planning policies attach great importance to the green belt, with the NPPF stating that substantial weight should be given to any harm to the green belt. Inappropriate development is, by definition, harmful to the green belt, should not be approved except in very special circumstances. Policy SS10 of our local plan is entirely consistent with this approach and as such has full weight in the determination. Next slide, please. Current extensions to the dwelling, as shown in the bottom left drawing, result in a 70% increase over and above the original dwelling, and the proposal would therefore represent a 95% increase in volume over and above the size of the original dwelling. This, added to the overall bulk and massing of the extension, is considered disproportionate, and so the resultant extension is considered to be inappropriate development. Spatially, the proposal is to the front of the building, forward of the previous extension. This would be development where there is currently none, and so spatially there would be an adverse impact on the openness of the greenbelt. The previous extension has significantly altered the original dwelling. The current proposal would further diminish the character of the original dwelling and be visually more imposing, extending the dwelling towards the road. The impact on the public realm would therefore also adversely impact on the visual openness of the greenbelt. The spatial and visual impacts of the proposal are therefore considered significantly and largely unaltered from that of the previous refused application, which was 24-00403 FLH, which was also dismissed on appeal, and the details for this are shown in the next slide. The primary difference between this application and the previously refused application is that a previously proposed study would be replaced by an enlarged landing space with a Velux roof line to it, resulting from the flat roof proposed being changed to a front pitch. A basement was also proposed previously. Very little has therefore altered from the previous scheme, and so in this respect the inspector's conclusion in dismissing the appeal that the scheme would amount to inappropriate development in the greenbelt, and the presumption against inappropriate development means that this harm alone attracts substantial weight. The development would also have a limited adverse effect on the openness of the greenbelt. The development would therefore conflict with the essential characteristics of the greenbelt as set out in the National Planning Policy Framework. Remains entirely relevant. Officers agree with this and take the same stance regarding the current application. Next slide, please. The applicant proposes that in approving the application scheme, the householder permitted development rights as set out above could be revoked. An illustration of the potential development on site that could have been undertaken using permitted development rights has been given. However, these are a largely theoretical possibility rather than being a worked up and/or the subject of a formal scheme or application to the authority. In addition, they relate to a rear extension and dormer along with a large outbuilding, and no quantitative or qualitative assessment has been undertaken of them. Therefore, officers attribute this potential fallback little weight and consider that any permitted development removal would not outweigh the harm that would be caused by the extension proposed. Overall, this proposal as set out by the applicant is not considered to represent very special circumstances necessary to clearly outweigh the harm caused to the greenbelt, and there is no evidence submitted to demonstrate such circumstances exist. The applicant, in suggesting the removal of permitted development, is accepting that the proposed extension represents an inappropriate form of development in the greenbelt, and the PD right classes A and E would remove Class A, which is extensions, Class B and C, which is alterations or extensions to the roof, Class D, which is porches, Class E, which is outbuildings, and all could be removed. These rights could be removed by condition anyway, and the committee is within its powers to do that in approving any scheme. But in any case, there is always the option to apply for planning permission for extensions buildings, even if this PD is removed, and in any event, an application to remove the condition as a whole can be made, potentially opening up PD rights again. The government sets out PD rights should not be removed except in exceptional circumstances, and if committee are minded to remove the PD rights as a very special circumstance in this case, in terms of consistency, they're also suggesting that these could be removed anyway. anywhere and for anyone as a very special circumstance. So in light of the above considerations, it's concluded that the proposal is considered an appropriate development in the green belt and there are no very special circumstances to clearly outweigh this harm. It is therefore contrary to policies SS10 of the local plan and the policies of the NPPF. Slides 9 and 10 show the dwelling from the front, from the highway and just inside the drive. And slide 11 shows the view over the surrounding countryside from the garden, just to give some context of the site. Before I finish, Chair, I just want to draw attention to a late representation that came in from a Mr. Tingay. This was after the late rep's report had been published. It details some design matters, but these are not considered to add anything new to the support comments that we've had previously that you know about. Thanks, Chair.
Thank you for that, Ken. Right, we have 3 speakers on this, 4 speakers, sorry, on this application. The first, which is Councillor Alex Dale, the ward member. When you're ready, Alex.
Thank you, Chair and members. Thank you very much for the opportunity to address you today. I'm speaking in support of this application, which proposes a modest 2-storey front extension to an existing dwelling in Hundall. While the site is within the designated green belt, I believe this is a case where a balanced, proportionate assessment is warranted, one which recognises both the planning merits of the proposal and the very real personal circumstances involved. The officer recommendation is based primarily on Greenbelt policy and a volumetric calculation, which suggests a 95% increase over the original dwelling pre-1948. However, both national and local policy make it clear that proportionality is not determined by volume alone. The key test is whether the addition would be disproportionate and whether it would cause harm to the openness and character of the Greenbelt. In this instance, the proposed extension is sited within the domestic curtilage, does not project forward of the original building line, and introduces a pitched gable design that reflects the original architecture. It is a clear improvement on the previously refused scheme, with the basement removed and the scale substantially reduced. Officers acknowledge that the proposal would not harm the surrounding landscape character, tranquility, or residential amenity. The impact on the street scene is absolutely minimal, and furthermore, no objections have been raised by neighbours or statutory consultees. The site is already fairly well screened. A critical material consideration is the applicant's offer to remove permitted development rights for classes A to E. This is not speculative, it's a binding proposal that would allow the council to retain control over future extensions and importantly prevent potentially much larger and more visually intrusive developments that could otherwise be built under national permitted development allowances. The irony is that under current legislation, this dwelling could be extended significantly further to the rear and sides, potentially up to a 400% increase in volume without planning permission. This application represents a far more controlled and visually coherent alternative. I also wish to raise the wider perception of fairness in our decision making. Residents will understandably find it difficult to reconcile a refusal of a modest extension such as this, when the council is about to prepare to release hundreds of acres of greenbelt land to meet increased housing targets equating to 164% uplift on previous allocations. That context cannot be ignored when we are assessing whether this application constitutes an unacceptable level of harm. Finally, I would highlight the exceptional personal circumstances of the applicants, which you'll hear more about. They're seeking to accommodate the needs of their daughter and grandchildren, one of whom has complex additional needs. And this proposal has been carefully designed to meet those needs with minimal external impact. And while personal need alone cannot justify the development, there's already a finely balanced assessment. It is a legitimate material consideration. So in conclusion, the proposal reflects a thoughtful design response, delivers a practical solution to a pressing family need, and enables tighter control for future development. I would urge the committee to take a pragmatic and proportionate view and approve the application today. Thank you, Chair.
Thank you, Councillor Dale. Do members have any questions for Councillor Dale? No? If you'd like to retake your seat then. Thanks, Alex. Our next speaker is a supporter, Aidan Stimpson. If you'd like to take your seat, please, at the speaker's table. You've got 3 minutes when you're ready. Thank you.
I don't think I'll need 3 minutes. I think Alex Dale's kind of covered everything that I would have said. I just don't understand it. Can I ask questions to the planning people?
No, sorry, that's not part of the
Right, okay.
process.
I mean, I've done building and extension work for the past 25 years. I've never really seen so much of an objection for such a small extension in comparison to the size of the site. And yeah, you say that in 1940 something it was half the size, but things grow, everything grows. So I just don't get it. I really don't. And obviously this is the second proposal. So they can build at the back to increase the percentage and at the side to increase the percentage. So I don't get just that little corner at the front. I really just don't get it. I might just be thick, but I just don't get it. So.
I'm sure officers will answer that later on in the
Can I just ask, has anybody been up to the site, apart from the one person that took the photos?
I've driven past.
You've driven past? Yeah. Right, okay. What's your opinion?
That's not. We're in a debate at the moment. We're going to go through the process, and then we'll have a debate, and then you'll know my opinion.
Right, okay.
All right, thanks. Sorry, do members have any questions? No? No, you're all right. I think you're okay to retake your seat. Thank you. Our next speaker is the applicant, Jane Johnson. If you'd like to take your seat, please. You've got 3 minutes when you're ready.
Thank you. So, good afternoon all, Chair and members of the committee. My husband and I are a family-orientated couple deeply committed to our 4 grandchildren. Our primary goal in purchasing our home was to secure a family house for life, close to our grandchildren, particularly our youngest grandson, who has a EHCP level 5 in place at Unston School. We chose this property because we cherish spending time at home and in our garden surrounded by the beautiful countryside. We've meticulously designed a modest and localised addition to our house, not only to meet our family's evolving needs, but also to ensure it seamlessly integrates with our surroundings. I want to stress that the front of our house will extend no further forward than the existing structure. The extension is only for part of the house. Passers-by truly wouldn't notice any difference from the road. The visual impact on the green belt and the area will be absolutely negligible. So much so that we are sure that there would have been no issue if this extension had been carried out pre-1948. Our proposed changes are also more in keeping with the original property than the current 1980s extension. Frankly, we are, along with the professionals involved, genuinely shocked that such an insignificant change could have ever been a planning issue. We invested all our savings into this property in good faith, believing that this minor alteration would be straightforward. Now we face an urgent family situation. Our daughter and her children need to live with us. Their youngest child is autistic and has dyspraxia, and maintaining stability and routine is paramount to prevent deregulation of his condition. Any disruption could severely impact his progress. The modest extension we propose is not a luxury but essential to provide the necessary living and therapy space to maintain this crucial stability for him. We understand planning regulations mean that ironically we could undertake larger, more imposing extensions under permitted development rights. However, we are fighting for this specific minimal impact proposal because we believe it's a clear case where common sense should prevail over interpretation that would ultimately lead to a more impactful development on the green belt. Our design is far more in keeping with the original property, avoiding the appearance of a stark out-of-place addition. Looking at other properties in Hundall with their extensive, sometimes incongruous extensions, we feel a profound sense of injustice and unfair treatment. The stress and health impact this process has caused our family is immeasurable. We are risk averse and would never have entered into anything where the impact on our surroundings would result. This refusal has caused huge upset and distress, and we are in desperate need of carrying out renovations, not least to prevent any disadvantage to our grandson. In all honesty, we simply want to maintain and preserve the lovely character of Hundall. We genuinely cannot comprehend how this truly modest extension, well within our boundary and distant from neighbours and the road, could possibly be seen as impacting the hamlet. We implore you with every ounce of hope we have left to evaluate our proposal on its own clear merits and allow common sense to guide your decision today. Our family's stability and our grandson's future hangs in the balance. Thank you.
Is that it? We've got 3 minutes up. Thank you. Do members have any questions for the speaker? No? If you'd like to retake your seat then, please. Final speaker as this is Anthony Johnson, who is speaking on behalf of the agent today. You have 3 minutes when you're ready. Thank you.
Thank you. Thank you, Chair. I'm going to read out a statement prepared by the agent who wishes to make his apologies for being unable to attend to read in person. This current application is different from the previous refused application in design, which was previous refusal of flat roof 2-storey street facing extension. This new current proposal is for a more sympathetic gable street facing extension to mirror the original host building and not be forward of the building line of the original dwelling or wider than the previous approved extension. This does not class as an intrusion into open countryside, nor does it affect the street view presence of the building, only creating a more sympathetic street view, reflecting the original gable-fronted dwelling design. So there is no increased impact or effect on the current street scene. This current application is a reduction of over 50% in the volume of the previous refused application, so is not a reflection of the previous application as stated as a reason for refusal. This new proposed extension, when added to previous extensions, is 95% of the volume of the original host dwelling. National policy appears to be 100% allowance. Therefore, the extension is not over and above the volume of the host dwelling as stated as a reason for recommending refusal. The previous refused application was in excess of 250% enlargement. The previous refused application did not include removal of PD rights. PD rights would enable the mass of the host dwelling to be extended over 400% in volume of original dwelling without needing planning permission. As volume is a concern in the previous and current application, we're prepared to accept this self-imposed condition to prevent the dwelling being extended in volume and accept only 95% increase in volume of the original dwelling, which we feel is a more favourable proposition. We've noted other dwellings in the village have been extended over 100% in volume, and it would be unfair to allow others the increase in volume, but not my client. My client's needs and circumstances have changed, and their daughter will now be moving back in with them, with her children, with one of the grandchildren having special needs, and my client's family desperately need more space to accommodate their family. Therefore, to conclude, this new revised application with PD rights removed would be a reduction in future building volume possible. This would reduce further potential development of the property, which is the main reason for previous refusal. This application is more than 50% of the volume of the previous refused application. I trust and hope that these points are taken into account when determining this application. Yours truly, Andrew Pearson.
Thank you very much. Do members have any questions? No? If you'd like to retake your seat. Thank you. Right, members, it's now time for questions to officers. So, have we got anybody who's got any questions for the officers? Councillor Foster?
Yeah, thank you, Chair. My question's based around the inappropriate development, in that the reason it's classed as inappropriate development is because of what's considered disproportionate additions from the original building. And I get that when we look at the table that's been provided, that it's 95% increase over the original. But that was 1947, and if you look at it from how it's been for the last 40 years, from 1985, so for a lot of people in living memory, how it's been, the proposal is a mere 15% over that. Now, I know we're supposed to consider the original building from 1947, but for all intents and purposes, in living memory, it's from 1985. It's the last, it's been there 40 years as it is, and we've got applicants asking for a mere 15% difference. So for me, I'd asked officers, is there anything that we've done before to be able to use that 1985 figure? Is there any precedent we've got? Has it been considered before, rather than having to go right back to 1947? Because that's just after the Second World War. It seems a bit, it doesn't seem appropriate for me, for us as committee members, to be speaking to residents that it's relevant, you know. That's not in, for me, I know for some people it's not in living memory. 1985 is where most of us remember these buildings from. So it seemed much more appropriate. Is there nothing officers can do for us to make that consideration? Thank you, Chair.
In answer to that, not to my knowledge. The legislation sets out clear that it's additions over and above the original, and the 1985 situation would not be original. So as far as I'm concerned, I've not considered and looked at every single green belt application, but to my knowledge, I'm afraid not.
Can I just add to that, Chair? As Ken says, the short answer to Councillor Foster's question is no. The original building is 1947, and that's set out in planning practice and policy. And in particular, Chair, this issue has been, in effect, considered by the inspector in dismissing the appeal a mere 7 months ago. And all these issues have been considered then. The scale and size of the extension is, for all intents and purposes, the same. And as officers, Chair, we're seeking to advise members on the back of your own policies, which have been considered by the council previously and by an independent inspector, and we're seeking to advise you on that. So in backing up what Ken says, the short answer to Councillor Foster's question, Chair, is no, there is nothing that officers can advise that would set aside the original building being set at 1947.
Thank you, Adrian. Any more questions for officers? No? Right. Oh, sorry, Councillor, yeah.
Yes, could the officers comment on, I think, Mr Stimpson's comments that a bigger development would have been, you know, it could have done a bigger development if it was at the back of the house? What he was saying there.
Well, Ken may have something to add to this, Chair, but every house, as members are aware, have permitted development rights to undertake development. That applies to land in Greenbelt or not. We're advised by government that we should only take away those permitted rights in exceptional cases because they're granted by government for a reason. And again, as Ken pointed out in his presentation, Chair, even if you were to consider that a very special circumstance, I would question that reasoning, because why is this very special in that circumstance? Why would you not do this in any application in Greenbelt? And to me, this isn't set aside from every other site where we have extensions for development in Greenbelt. I don't, as officers, we don't believe they represent even special circumstances. They're just circumstances and wouldn't classify as very special circumstances. But yes, they are permitted by government for reasons that government have. But again, as Ken mentioned, even if you were to do that, there's still potential for that condition to be removed by way of appeal or by way of application to this council and its removal. And that's certainly been the case in circumstances we've had before, where we've taken away those rights and permissions been granted. So I don't think, as an officer advising you, that is a very special circumstance that would outweigh the other harm that's been identified. And again, as officers, we believe that could be easily taken away through application or appeal, and therefore you would be left having granted this with still permitted rights. And the final point, again, as was made, if the inspector had felt that was tipping matters or could tip matters, that would have been open to him in determining the appeal a mere few months ago.
Thank you, Councillor Foster.
Looking at it from another angle, looking at very special circumstances, could we not, as a committee, consider very special circumstances to be hardly any harm to the, and I know it's by definition, but there's so little harm, it's not severe, there's no complaints, there's hardly any increase in the present volume at all, just the actual effect on the harm of the Greenbelt. When we consider, which has been mentioned by Councillor Dale, and I know it's a hot topic, but this council is about to give permission to build all over the Greenbelt for the north. All over. It's going to cover the whole of Kilmarsh. It will happen.
That is not part of this debate.
I know it's not material
We're discussing
consideration.
this property, so if you can
I
bring
know
it
it's
back
not
to
material
that.
consideration, I've got that. But when you look at what's about to happen to the whole district, this is just a
Look,
small point.
Councillor Foster,
I've got that.
I'm asking you
I've
to
got
come
that.
back.
I've got it.
We debated this
I've got it.
application before us, so stop discussing
got
the
it.
future local plan. Thank you.
I've got it. Yeah.
It didn't sound
so-
like you did
so-
because you carried on.
So could that not be a special circumstance, the actual quantity of harm? Thank you, Chair.
You have to go through the process, and again, we discussed this before. Is the development, first of all, inappropriate development or not inappropriate development? And I think everyone is agreeing that it is inappropriate development. And therefore, by definition, there is harm to Greenbelt, as set out by the inspector. To override that, very special circumstances have to clearly outweigh that harm. Clearly outweigh, so not just outweigh, clearly outweigh. So it's quite a test. It's for you as members to take that into account. Do you believe there are very special circumstances in this case? So not just circumstances, not just special circumstances, very special circumstances in that case to outweigh that harm by definition and any other harm. And the inspector concluded that there was harm by definition because it's inappropriate, but there was also some further harm to openness, and that's set out in his conclusions. In taking that into account and these circumstances, you've got to be certain that they are very special. So not just circumstances that are easily replicated elsewhere. And I think all that we've been given as officers in terms of the removal of the PD rights is, in our opinion, not very special because they could be easily replicated elsewhere. So in terms of balancing that, it's for you as a committee to consider whether there are any very special circumstances. Officers don't consider that there are, and that's a view that's been considered by the inspector a mere few months ago. And in all cases, I would exercise extreme caution in placing weight on other circumstances because they can be easily taken away. So I just always express caution in terms of the other things that you've heard this afternoon, which weren't offered to us as part of the application in advising you, but I would always express caution in that. But ultimately it's for you, Chair, and the committee to weigh up whether there are very special circumstances that would clearly separate this site away from others and therefore cannot be easily replicated. I hope that's clear.
Councillor Baker.
Thank you, Chair. So, just for clarity then, largely for my benefit, but I think I'm right in what I'm saying, the proposed extension, if you like, or the additional accommodation, let's phrase it that, could be provided by permitted development rights, but elsewhere on the building in a different configuration. It doesn't need to make it into a double-fronted property, is what you're saying.
That's not what we're saying.
No.
But that may be true. But we've not been faced with another worked up scheme that would demonstrate that. So it's impossible for me to answer that question. But again, as the Chair's pointed out, we're considering what we've been asked to consider by the applicants and brought to...
The reason that I'm asking is I'm trying to get a feel for the speakers that this extension is essential in its format. That's the message I got. And I'm trying to get a feel for whether that is supported. Is there any weight in that argument? That's what I'm trying to get a feel for. As the scheme as drawn.
We've not been given any substantive evidence to say this is the only scheme that will deliver what is required. And as you've heard, permitted development may give a scenario that this level of accommodation could be provided on the site, because certainly in terms of outbuildings there are significant allowances for large buildings within domestic curtilages. But I'm sorry, we've not been faced with an alternative that would be able to answer that question. I think that's right, Ken.
Thank you.
Any further questions for officers? No? Right, I will open the floor for debate. Does anybody want to start off? Councillor Baker.
Well, I'd reiterate a comment I've just made then. It seems to me that, having had some experience in designing buildings, there within the permitted development rights, there may be an alternative scheme which could be developed without going against officers' recommendations and the previous inspectors' comments about affecting the openness of the greenbelt. And so I'm not, at the moment, I'm prepared to listen to argument, convinced that this is the only viable scheme that can be done at this property.
Okay, thank you, Councillor Baker. Anybody else? Councillor Cheetham.
Thanks, Chair. I just think it's a little bit of like many applications that come our way, it's a bit of a head and a heart decision we need to make. And I do have great sympathy for the applicants. But it just feels like if it's a drip effect, and you know, it's only this and it looks quite nice. I think we need to we're wary of the precedent that we set for future applications. So that's the way that my mind is headed at the moment.
Thank you, Councillor Gay.
Yeah, I agree with the previous speaker. I've got a lot of sympathy, and I know I know that row of houses in Hundle, and it is very much screened from the road and so on and so forth. I have got a lot of sympathy for it, but we should be worried about precedent, I think, shouldn't we? Because where does that leave us?
Thank you, Councillor Gay. Anybody else? Well, I'll put an in, but I think we've got to also remember policy on this. We put these policies in place to protect the greenbelt. The MPPF does that, and so does our current local plan. And we've got to, with what officers have said with regarding special circumstances, I can't see any special circumstances that outweigh the rules that we've set down in the local plan, you know, under SS10 and under the National Planning Positive Framework, and I can't see how we can support this. Anybody else? Right, I'll open the floor to a motion. Councillor Lacey?
Yeah, I'm going to move that we go with officers' recommendations for the simple reason policy SS10 and the MPPF recommendations.
Thank you, Councillor Lacey. Councillor Baker?
Second that, Chair.
Okay, thank you. Right, we'll put that to the vote. Thank you, members. That's 7-4 and 1 abstention. Thank you, members. Right, item 8 on the agenda is regarding the report on appeals lodged and determined. So I believe you're leading on this one, Adrian. So I'll hand over to you.
Thanks, Chair. Just first of all, on page 39, you'll see the latest number of appeals that have been lodged, and they continue the more than a steady stream of appeals that we get in, so we'll be dealing with those over the coming weeks, and in particular some members are particularly aware that the number one of that list of lodged appeals, the Red Mile appeal, is due to be heard by way of informal hearing towards the end of next month. So they'll continue the steady stream of appeals that we're getting in, and we'll be dealing with those in due course. Just on the appeals allowed and dismissed, Chair, first of all, there's a correction that the Mr. William Calvert appeal was actually allowed, so that's in the wrong location there, and I'm sorry for that error. Just in terms of the appeals that were allowed and dismissed, just setting aside for a moment the enforcement appeals, the appeals in relation to Ms Meehan and Mr Calvert are interesting in that they were decisions taken prior to the changes in the MPPF at the back end of last year, and the change in emphasis of the MPPF in terms of the redevelopment of previously developed land is reflected in those two appeals. So when you've read them, that may be something that you've picked up, that there is now the requirement in respect of previously developed land for development to, and I apologise that I'll probably get the adjective incorrect, and my colleagues will, I'm sure, correct me, but any harm must be substantial. So there must be substantial harm to the Greenbelt in terms of that redevelopment, where previously it was just greater harm. So members in making decisions and officers in advising members will be seeking to make that clarification going forward. So those two appeals were pre-MPPF changes, and subsequent decisions will need to reflect the different bar that's been set out in the MPPF in terms of Greenbelt harm on previously developed land. I won't go into the debate about Greybelt here because that's a whole other ball game, but we may need to have that debate down the line, Chair. Just in terms of the Mr Sharp appeal, that's quite an interesting appeal in terms of the site, because members may recall that the council granted permission for the conversion stroke building of a dwelling on the site at Milltown. That's still to be constructed, but in terms of the barn that Mr Sharp sought permission for, the inspector dismissed that appeal on the back of there in effect being no agricultural or other similar activity taking place on the site as it stands. So an interesting decision which I'm sure members will have read, but that's got quite some pertinence in relation to that. And just in terms of the enforcement appeal, Chair, that relates to grounds outside planning merits, but again always worth reading the enforcement appeals because they go into detail on various aspects of planning that are an interesting account. And just in terms of that particular appeal, the officer involved, Mr Hawley, put in a lot of time and effort to deal with that at inquiry, so his efforts in getting that outcome are to be noted, Chair, and I've asked you to do that. Thank you. Hope that helps just give some some flesh to those bones.
Councillor Foster.
Thank you, Chair. Yeah, my question's about the Calvert appeal. So, correct me if I'm wrong while I'm going along. Officers made the decision to refuse based on greater harm. Yeah. And the inspector of the appeal made the decision to overturn that based on substantial. Is that correct?
Effectively, yes.
Yeah. So that's how that worked. Yeah. So they used the new MPPF to determine the appeal. So if that's correct, my question is, how long will this continue? How long are we going to see this carry on? The difference between decisions we've made and the new policies which are being considered on appeal. Obviously, we're going to face that with the Red Mile case, the DR1 case. That's going to be judged on that. I've got that. But how much longer into the future will the council be affected by the change in policy? Thank you, Chair.
Just in terms of Councillor Foster's initial question, there'll probably be, I would have thought, another 3-4 months of that as the appeals that were the applications that were dealt with up to the end of 2024. They have 6 months for appeal and they are dealt with. So potential that some appeals may not yet have been lodged on decisions taken pre-MPPF changes. There's only a week, but there may still be 1 or 2 that are in the system and coming through. But then they'll need to be assessed by inspectors and decisions handed down. So there may well still be a few months yet of those. Interestingly, just in terms of the Meehan appeal, Ms Meehan, that was actually dismissed, but that was for biodiversity net gain reasons rather than greenbelt reasons. So again, as you've read that, you'll have come across that's been helpful to us in terms of some of our biodiversity net gain, the issues that we're finding on that, and Alice will correct me because this probably will be wrong, but in terms of, I think it's custom and self-built properties. So that's been a useful guide in respect of that, and the inspector in the Meehan case, whilst going against the original decision for the Greenbelt grounds, has brought some justification to our policy in terms of BNG, biodiversity net gain, which has been, thanks to Alice's work, that's been very, it's been good to have that feedback that we've actually been practicing that element of what we're doing seemingly correctly. So that's good. The Red Mile appeal, just briefly, that will be judged not on the Greenbelt issue though. That's an allocated site, so that the issue of substantial harm on the Greenbelt won't be applicable to that. It'll be other issues, design, impact on neighbours, and those that were part of that refusal. Hopefully that helps.
Okay, any further questions for Adrian on the report? No, thank you. Right, I have, do we'll note with the report, just to show a quick show of hands and say we note the report. Thank you, members. Right, I have no urgent business, so we will move on to item 10, which is exclusion of the public. I move that the public be excluded from the meeting during this discussion of the next item of business to avoid the disclosure to them of exempt information as defined in paragraphs 3 and 5, part 1 of Schedule 12A to the Local Government Act 1972, as amended by Local Government Access to Information Variation Order 2008. So if you can just let us know when the live streaming's finished, please, Martin. Right. Is this who's dealing with this?
I can just briefly take members'